दोस्तों, इंटरप्रिटेशन ऑफ स्टैट्यूट्स की सीरीज़ हम कर रहे हैं और एक्सटर्नल एड हमारा चल रहा है। इसमें पार्ट 3 जो है दैट इज़ जुडिशियल डिसीजंस एंड प्रेसिडेंट्स। सो दैट टॉपिक वी विल कवर इन दिस लेक्चर। और यदि आपको हमारे लेक्चर्स पसंद आ रहे हैं, ऑफ कोर्स आपके व्यूज़ और आपके सब्सक्राइबर जो नंबर बढ़ रहा है उसको देखते हुए लग रहा है कि आप वीडियोस को पसंद कर रहे हैं, तो हमें यूट्यूब पर ज़रूर फॉलो करिए। तो देखिए दोस्तों, जो आज का टॉपिक है दैट इज़ जुडिशियल डिसीजंस एंड प्रेसिडेंट्स। इसको शुरू करने से पहले प्रेसिडेंट का जो डेफिनेशन है वो एक बार समझ लें। देखिए, जो प्रेसिडेंट है, सामंत कह रहे हैं प्रेसिडेंट इज ए जुडिशियल डिसीजन विच कंटेन्स इन इटसेल्फ ए प्रिंसिपल, यानी उसके अंदर कोई ना कोई सिद्धांत होता है। The underlying principle which thus forms is authoritative element। और हर प्रेसिडेंट में, यानी कि जो कोई भी ऐसा डिसीजन है कोर्ट का जो लैंडमार्क जजमेंट हो गया, उसको हमने प्रेसिडेंट कह दिया। जो इम्पोर्टेंट जजमेंट है उसके अंदर कोई ना कोई सिद्धांत रहता है जिसकी वजह से उसकी अथॉरिटी बन जाती है। नाउ द की इनसाइट इन दिस डेफिनेशन इज दैट सामन बेसिकली क्या कहना चाह रहे हैं कि सारे का सारा जजमेंट नहीं, बल्कि जो लीगल प्रिंसिपल है जिसे हम रेसो डिसेंडाई कहते हैं। जजमेंट के जो दो पार्ट रहते हैं, एक तो रेसो डिसेंडाई, एक ओबिटर डिक्टाल। जो रेसो डिसेंडाई है दैट इज़ द बाइंडिंग पार्ट ऑफ द जजमेंट, वो आपका बाइंडिंग प्रेसिडेंट होगा। एंड द सेकंड डेफिनेशन है दैट इज जॉन चिपमैन ग्रे, द ओपिनियन ऑफ ए जज विच इज़ नॉट नेसेसरी फॉर द डिसीजन ऑफ केस इज़ नॉट बाइंडिंग, जिसको हमने ओबिटर डिक्टा बोला है। क्या बोला है? ओबिटर डिक्टम कह देते हैं या ओबिटर डिक्टा कह देते हैं। वो बाइंडिंग पार्ट नहीं है। ए प्रेसिडेंट कवर्स ओनली व्हाट इज एक्चुअली डिसाइडेड, राइट, नॉट व्हाट कुड हैव बीन डिसाइडेड, व्हाट इज एक्चुअली डिसाइडेड, यानी कि प्रिज्यूम्ड डिसीजन की बात नहीं हो रही है। दैट इज व्हाट एक्चुअली इज, दैट विच एक्चुअली हैज बीन डिसाइडेड। सो इन दिस डेफिनेशन बेसिकली ग्रे डिस्टिंग्विश, what he is distinguished is basically the binding element, that is reso decidendi, and non-binding dicta, that is obiter dicta in judicial decisions। अब जो कीटन है, कीटन बेसिकली जिन्होंने एलिमेंट्स ऑफ लॉ बुक लिखी, कीटन कह रहे हैं कि जुडिशियल प्रेसिडेंट इज ए डिसीजन विच सर्व्स एज एन अथॉरिटी फॉर डिसाइडिंग ए लेटर केस, यानी कि अथॉरिटी फॉर फ्यूचर केसेस बन जाता है, लैंडमार्क जजमेंट बन जाता है। एक बार जो बात कह दी और अच्छे से कह दी और बहुत सारे लोगों ने कह दी, जैसे केशवानंद भारती केस में मान लीजिए 7:6 का रेशियो था, 13 जज थे, तो 7 लोगों ने जो बात कह दी, 7 जजेस ने, वो बार बार तो नहीं कहेंगे, वो अथॉरिटेटिव वैल्यू उसकी बढ़ गई है क्योंकि वो लार्जेस्ट बेंच था केशवानंद भारती में। नाउ Keaton basically here underscores the authoritative value of a decision in shaping outcomes in similar future cases। यानी कि बार बार हम ये बात नहीं कहेंगे कि पार्लियामेंट हैज़ अथॉरिटी टू अमेंड द होल कॉन्स्टिट्यूशन एक्सेप्ट द बेसिक स्ट्रक्चर। ये बात क्लियर हो चुकी है। नाउ ब्लैक लॉ डिक्शनरी के अंदर देखें, अगर प्रेसिडेंट इज एन एडजस्ड केस और डिसीजन ऑफ ए कोर्ट considered as furnishing an example authority for identical or similar cases afterward arising, यानी कि फ्यूचर केसेस में जो सिमिलर केस अगर फ्यूचर में आ रहे हैं तो उसके लिए वो एक एग्जाम्पल या अथॉरिटी बन जाता है। और ये ऑलरेडी डिसाइडेड केस है, यानी कि सबसे पहली बात तो ब्लैक लॉ डिक्शनरी कह रहे हैं कि वो एक डिसाइडेड केस होना चाहिए। दूसरा, वो एग्जाम्पल या अथॉरिटी होना चाहिए। और किसके लिए केस होगा? सिमिलर केसेस के लिए, ठीक है, आइडेंटिकल और सिमिलर केसेस 4, और किन के लिए होगा? आने वाले केसेस के लिए। यानी कि ये 5 एलिमेंट ब्लैक लॉ डिक्शनरी में बड़े क्लियर से बता दिए। नाउ दिस इज़ वाइडली cited legal dictionary and it defines precedent in terms of its referential authority for रेफरेंशियल अथॉरिटी फॉर लेटर केसेस, ये कितना सुंदर वर्ड है, देखिए रेफरेंशियल अथॉरिटी, राइट। प्रेसिडेंट का मतलब रेफरेंशियल अथॉरिटी फॉर लेटर केसेस, एक लाइन में भी इसको हम कह सकते हैं। प्रेसिडेंट इज रेफरेंशियल जुडिशियल अथॉरिटी, इसको जुडिशियल वर्ड ऐड कर देते हैं। प्रेसिडेंट इज रेफरेंशियल जुडिशियल अथॉरिटी फॉर लेटर केसेस, तो ये इसका एक वन लाइन का डेफिनेशन ये हो जाएगा। अब डायस और ह्यूज जिन्होंने जूरिस्प्रूडेंस किताब लिखी, वो कह रहे हैं कि प्रेसिडेंट इन्वॉल्व्स द एप्लीकेशन ऑफ प्रिंसिपल्स, application of principles laid down in previous decisions to new cases, यानी कि प्रीवियस डिसीजन होना चाहिए, उसमें एप्लीकेशन ऑफ प्रिंसिपल्स होना चाहिए और न्यू केसेस के लिए होगा। इट इज़ द फाउंडेशन ऑफ लीगल सर्टेनिटी एंड प्रेडिक्टेबिलिटी। तो प्रेसिडेंट से क्या होता है, लीगल सर्टेनिटी आती है, प्रेडिक्टेबिलिटी आती है। And key insight in this is that they focus on the role of president in ensuring consistency and predictability in judicial decision making. जस्टिस बेंजामिन कार्डोजो यूएस सुप्रीम कोर्ट के कह रहे हैं कि द कंसेप्ट ऑफ प्रेसिडेंट इज द वे थ्रू विच द पास्ट गवर्न्स द फ्यूचर, पास्ट गवर्न्स द फ्यूचर। इट सिक्योर्स यूनिफॉर्मिटी and certainty in the application of law. Uniformity and certainty in application of law. Key insight in this definition basically is the philosophical and practical importance of precedent in stabilizing law. यानी स्टेबिलिटी पर फोकस कर रहे हैं जस्टिस बेंजामिन कार्डोजो। देखिए, जुडिशियल डिसीजंस, दीज आर रूलिंग्स मेड बाय कोर्ट इन स्पेसिफिक केसेस। व्हेन इंटरप्रेटिंग स्टैट्यूट्स, जजेस मे रेफर टू प्रीवियस जजमेंट्स। ऑफ कोर्स वन शुड, और दे ऑल्सो आर डूइंग द सेम, रेफरिंग टू द प्रीवियस जजमेंट्स टू अंडरस्टैंड हाउ सिमिलर केसेस हैव बीन हैंडल्ड। हम कैसे, हमने सिमिलर केसेस को पहले हैंडल किया है, तो वैसे ही फ्यूचर में भी हैंडल करेंगे। नाउ द प्रेसिडेंट बेसिकली आर प्रिंसिपल्स और रूल्स एस्टैब्लिश्ड इन प्रीवियस लीगल केसेस दैट courts are bound to follow under the doctrine of stare decisis. Stare decisis का मतलब to stand by the decided matters that has already been decided should be decided in the same way. Now particularly in common law systems, और इसके लिए हम आर्टिकल इंडिया का 141 देख सकते हैं ऑफ कॉन्स्टिट्यूशन ऑफ इंडिया, that says that law declared by the Supreme Court is the law of the land. वो स्टेयर डिसाइसिस का बेस्ट एग्जाम्पल है, यानी कि सुप्रीम कोर्ट का सारे हाई कोर्ट्स पे बाइंडिंग होगा, और हाई कोर्ट का एक स्टेट हाई कोर्ट का उस स्टेट में जितने भी कोर्ट्स हैं उसके ऊपर बाइंडिंग होगा। तो ये दिस इज नोन एज डॉक्ट्राइन ऑफ स्टेयर डिसाइसिस। नाउ गोइंग फर्दर, as talking of external aids, the role of judicial decision precedents, judicial decisions are not part of the statute itself, यानी कि कानून का हिस्सा नहीं, but they are considered as external aids, right? And their primary role is to basically to clarify the ambiguity. So whenever the language of the statute is vague or open to multiple interpretations, courts look to prior decisions for guidance, right? Thereby to achieve clarity and avoid ambiguity and to ensure consistency. If we follow precedents, we promote uniformity and predictability in the law. So कोई भी नया क्लाइंट आता है या कोई भी आदमी जब कोर्ट के पास आ जाता है तो वो देख पाएगा कि कैसे सिमिलर केसेस में कोर्ट ने डिसीजन दिए थे, तो ही कैन प्रिपेयर हिमसेल्फ। इसलिए कंसिस्टेंसी का होना बहुत ज़रूरी है। स्टेबिलिटी, प्रोडक्टिबिलिटी, ये एक जस्ट एंड ह्यूमन जुडिशियल सिस्टम का पार्ट है. Now, sometimes the statutes are silent on specific issues, and courts use past judgment to bridge such gaps. Right? So, thereby, the judicial precedents and judicial decisions sometimes they are used to fill in the gaps where the law is silent, no express provision is there. Now, understand the legislative intent. Earlier judgments may include discussions on background, purpose, and objective of the law, and thereby it helps the court to understand actually the legislative intent. Going further, types of precedent. One is binding precedent, that is decision from higher courts that lower courts must follow. They are known as binding precedent. The second category of precedent is persuasive precedent. Decisions from courts of the same level और फ्रॉम अदर जुरिडिक्शन, एक हाई कोर्ट का दूसरे हाई कोर्ट के लिए परसुएसिव होगा, बाइंडिंग नहीं होगा, बट समटाइम्स दे मे इन्फ्लुएंस द डिसीजन. राइट. Going further, the limitations we are talking about of judicial decisions and precedents. Judicial decisions they can't override clear statutory language, यानी कि express provision of law को जुडिशियल डिसीजंस ओवरराइड नहीं कर सकते. ये तो हो गई पहली बात. नाउ प्रेसिडेंट मे इवॉल्व और बी ओवर रूल्ड, चेंज होते रहते हैं, ओवर रूल हो जाते हैं इफ दे आर आउटडेटेड और इनकरेक्ट इन लाइट ऑफ न्यू सोसाइटल नीड्स, जिसको जस्टिस होम्स कहते हैं फेल्ट नेसेसिटीज ऑफ टाइम, उसके हिसाब से होते रहते हैं. केस लॉ की बात करते हैं दोस्तों, तो केशवानंद भारती का केस, जब हम प्रेसिडेंट की बात करते हैं, लैंडमार्क जजमेंट की बात करते हैं, 1973 का सुप्रीम कोर्ट का 13 जजेस बेंच, लार्जेस्ट एवर इंडियन जुडिशियल हिस्ट्री, इसके बिना ये कंप्लीट ही नहीं होता है. और इस लैंडमार्क जजमेंट ने सुप्रीम कोर्ट ऑफ इंडिया ने इंटरप्रेट किया कॉन्स्टिट्यूशनल प्रोविजंस को बाय एक्सटेंसिवली रिलाइंग ऑन अर्लियर जुडिशियल प्रेसिडेंट्स, ultimately establishing the basic structure doctrine. This doctrine holds that while Parliament has wide and ample powers to amend the Constitution under Article 368, it cannot alter or destroy its basic structure, right? Such as principles of democracy, rule of law, and judicial review. They are examples and not the exhaustive list. They are examples of basic structure. Now, the background of the case goes like that. Kesavananda Bharati was a head of religious mutt in Kerala. He challenged Kerala Land Reforms Act 1963. और जब इनको केरला लैंड रिफॉर्म्स एक्ट को चैलेंज किया तो विच अफेक्टेड हिज रिलीजियस इंस्टीट्यूशन प्रॉपर्टी, एंड ड्यूरिंग द प्रोसीडिंग कॉन्स्टिट्यूशनल अमेंडमेंट, स्पेशली द 24th, 25th and 29th amendments, they became central, raising the broader question that can Parliament amend any part of the Constitution, including fundamental rights. Now, issues in this case involved were like, does Parliament have unlimited power to amend the Constitution under Article 368? Can Parliament amend or take away fundamental rights? Issue number 2. And the judgment was delivered on 24th of April 1973, and majority was 7-6. The majority held that Parliament can amend any part of the Constitution, including fundamental rights. However, it cannot alter the basic structure of the Constitution. Now, this led to the formulation of basic structure doctrine, a judicial principle stating that certain fundamental features like supremacy of the Constitution, secularism, democracy, separation of powers, judicial review, etc. Once again, the list is not exhaustive, cannot be destroyed or altered even by constitutional amendments. आप कॉन्स्टिट्यूशनल अमेंडमेंट से अंडर आर्टिकल 368 पूरा कॉन्स्टिट्यूशन को चेंज कर सकते हैं, पर बेसिक स्ट्रक्चर को चेंज नहीं कर सकते. इस केस का इम्पोर्टेंस, रेलिवेंस बहुत बड़ा है. Now the significance of the case once again is that it limited Parliament's amending power, ensuring core values of the Constitution are preserved, and became a constitutional cornerstone in India, balancing parliamentary sovereignty and judicial review. And it was cited in numerous later decisions to strike down constitutional amendments violating the basic structure. Case Law 2, State of Rajasthan versus Leela Krishna, EIR 1965, Supreme Court 1296. The Supreme Court of India addressed the importance of precedents in statutory interpretation. The court emphasized that when the language of statute is ambiguous or unclear, it is both legitimate and necessary to consider prior judicial decisions to clarify the meaning. The Supreme Court of India on 16th September 1964 addresses the scope of the state government's revisional jurisdiction under the proviso to Section 4 Clause 1 of Rajasthan City Municipal Appeals Regulation Act 1950. The background was that Mrs. Leela Jain constructed a building in Jaipur in violation of the approved municipal plans, and despite receiving a stop work order from the president of the municipal board, she proceeded to complete the unauthorized construction. Later, the president compounded the violation by accepting a nominal fine of rupees 101. Agreed by the construction, a neighboring resident, Mr. D. Goswami, submitted a petition to the state government exercising its revisional powers under proviso to Section 4(1) of the Rajasthan City Municipal Appeals Regulation Act 1950. The state government set aside the president's compounding order. 101 रुपये लेने से वो का order set aside कर दिया. In response, Mrs. Jain challenged the state government's action in the Rajasthan High Court under Article 226 of the Constitution. High Court चले गई Mrs. Leela Jain. She contended that the state government had no revisional authority over such municipal decision. The High Court upheld her argument and quashed the state government's order. Now, the decision by the Supreme Court. On appeal, the Supreme Court reversed the decision of the Rajasthan High Court. It held that proviso to Section 4 Clause 1 of Rajasthan City Municipal Appeals Regulation Act 1950 empowers the state government to revise orders passed by a commissioner or any municipal authority, including the municipal president. The court emphasized that when statutory language is unambiguous, it must be given effect as written and should not be overridden by interpretations based on statutes preamble or presumed legislative intent. इसको फॉलो नहीं करना है. प्रिज्यूम्ड लेजिस्लेटिव इंटेंट जो एक्चुअल में है उसको फॉलो करना है. एक होता है एक्चुअल लेजिस्लेटिव इंटेंट, एक होता है प्रिज्यूम्ड लेजिस्लेटिव इंटेंट. एक्चुअल लेजिस्लेटिव इंटेंट को प्रमोट करना है. अकॉर्डिंगली द सुप्रीम कोर्ट रूल्ड दैट द स्टेट गवर्नमेंट डिड पोजेस the authority to revise the municipal president's compounding order. However, since the High Court had not considered other grounds raised by Mrs. Jain in her petition, the Supreme Court remanded the matter for the High Court to examine those remaining issues. वापस भेज दिया हाई कोर्ट के पास सुप्रीम कोर्ट ने जो बाकी इश्यूज के ऊपर देखने के लिए. This decision is often cited as an affirmation that court should not interpret laws in isolation. आइसोलेशन में नहीं इंटरप्रेट करना है, कोर्ट्स को अलग अलग नहीं करना है, but in the context of past rulings when resolving statutory ambiguity. Now, key takeaways from this decision is that ambiguity in statutory language justifies turning to past decisions. अगर कानून में भाषा में कोई क्लैरिटी नहीं है तो पास्ट डिसीजंस के पास चले जाएंगे. Now the judicial precedents, they serve as guides to ensure consistency and coherence in the interpretation of laws. गाइड की तरह काम करते हैं. And the case reinforced the principle of stare decisis, promoting legal certainty and predictability. The significance of this case, once again, that This judgment underscores the principle that when statutory language is clear and unambiguous, it must be given effect as written. Court should not disregard explicit provisions based on statutes preamble or assumed legislative purposes. The case illustrates the judiciary's role in upholding the plain meaning of legislative texts, reinforcing the doctrine of literal interpretations in statutory construction. The case law 3, Keshav Mills Company Limited versus CIT 1965 का केस है. The Supreme Court highlighted the importance of judicial precedents while interpreting tax laws. It stressed that when a statute is ambiguous, past decisions should be considered to ascertain legislative intent. This case reaffirmed the principle that previous rulings offer valuable guidance in interpreting statutes, especially when ambiguity exists. This case is landmark decision by the Supreme Court of India, which primarily dealt with the issue of taxability of capital gains in the context of company's transfer of its capital assets. The background of the case goes that Keshav Mills Company Limited, the appellant, was a company engaged in the business of textile manufacturing. In this case, the company transferred certain capital assets, specifically the land and buildings, to a new company. यानी कि कंपनी ने अपने लैंड एंड बिल्डिंग एटसेट्रा जो कैपिटल असेट्स थे उसको नई कंपनी को ट्रांसफ़र कर दिया, which was formed for the purpose of acquiring the assets and carrying on business. The question at hand was that whether the transfer of these assets was subject to capital gain tax under the Income Tax Act 1961. Issue was that whether the transfer of capital assets like land or building by the company to the new company would result in capital gains tax liability. The company contended that the transfer was not liable to capital gains tax because the transfer was part of reconstruction or reorganization, and thus no gain, no loss had actually occurred. Supreme Court ruling was in favor of Income Tax Department. The court held that the transfer of assets was subject to capital gain tax, and the company should not avoid tax liability simply by asserting that the transaction was a reorganization. तो बड़ा क्लियर सा प्रिंसिपल इसमें एस्टेब्लिश कर दिया. द कोर्ट स्टेटेड दैट द ट्रांसफर ऑफ असेट्स from one company to another, even if it were for the purpose of reorganization, still would be taxable as a capital gain under the provisions of the Income Tax Act 1961. The fact that the transaction involved the formation of a new company or reorganization of the business did not exempt the company from the capital gains tax. The key takeaways are: capital gain tax, the transfer of capital assets like land or buildings from one company to another, was subject to capital gain tax. Reorganization is not a shield, or reconstruction, reorganization of a company does not automatically exempt it from paying capital gains tax on transfer of capital assets. And a taxable event number 3 occurs when transfer of capital assets takes place, and the taxability depends on the nature of the transfer, not the underlying purpose or motive behind it. केस लो 3, गोलकनाथ वर्सेस स्टेट ऑफ पंजाब 1967 का केस है सुप्रीम कोर्ट का. द सुप्रीम कोर्ट रूल्ड दैट अमेंडमेंट्स टू द कॉन्स्टिट्यूशन कांट अल्टर द फंडामेंटल राइट्स enshrined under it, right? And it relied heavily on previous judgments, including Shankari Prasad case. Interpreting constitutional provisions, it reflected the importance of using earlier decisions to interpret the Constitution's provisions and to ensure judicial consistency. This case is one of the most important constitutional law cases in India, which dealt with the issue of amendment of the Constitution and the power of Parliament to amend the fundamental rights. In this case, the petitioner Golaknath challenged the constitutionality of the Punjab Security of Land Tenures Act 1953, which was enacted by the state of Punjab to impose restrictions on the ownership and transfer of the land. The petitioners, who were landowners, argued that the act violated their fundamental rights under Article 19, that is right to property, and Article 31, that is to acquire, hold and dispose of property of the Indian Constitution. At the time, the Parliament had enacted several constitutional amendments that affected fundamental rights, including 17th Amendment, which had inserted certain land reforms laws into 19th schedule, यानी कि 9th schedule में ऐसे laws डाल सकते थे जो कि judicial review जिनका नहीं हो सकता, thereby protecting them from judicial review. The issue arose whether Parliament had the power to amend fundamental rights or whether these rights were unamendable. The issue, once again, was whether the Parliament had the power to amend fundamental rights under Part 3 of the Constitution, which guarantees fundamental rights, and whether such amendments could be made even if they violated rights of the citizen. The court ruling, that Supreme Court of India in landmark judgment, ruled in favor of Golaknath and held that fundamental rights were unamendable and could not be altered or taken away by the Parliament, even through a constitutional amendment. The court emphasized the following points: doctrine of basic structure. The court held that Parliament could not alter or amend the basic structure of the Constitution, and fundamental rights were part of the basic structure. This implied that fundamental rights could not be abrogated or amended even through the power to amend the Constitution under Article 368. No power to amend fundamental rights. The Supreme Court ruled that Parliament's power to amend the Constitution was limited and it did not extend to the amendment or alteration of fundamental rights. This decision reversed the earlier view of that Parliament could amend any part of the Constitution, including fundamental rights. 19th schedule is 9th schedule is an exception, and the laws placed in this schedule by way of amendments could still be subject to judicial review if they violated fundamental rights, as the 9th schedule could not be used as an excuse to bypass fundamental rights. Now, key takeaways are that fundamental rights are unamendable. The ruling established that fundamental rights are a part of basic structure of the Constitution and can't be altered by the Parliament. Parliament's amendment power is limited. The decision significantly limited the power of Parliament to amend the Constitution and laid down that no amendment can be made that violates the basic structure. 9th schedule laws including in 9th schedule could be subject to judicial review if they violate fundamental rights, even though these laws were intended to be insulated from judicial scrutiny. Now, impact of the judgment is case law 4, Indian Oil Corporation versus Amritsar Gas Service 1991 सुप्रीम कोर्ट केसेस में रिपोर्ट हुआ. द सुप्रीम कोर्ट emphasized interpreting the statute in light of past rulings, and it upheld the need for consistency in the application of laws and judicial decisions. This case reinforced the need to follow earlier judicial decisions in the interpretation of statutes to maintain legal certainty. Now, this case deals with the issue of sale of goods under a contract and the rights and obligation of the parties involved, especially concerning the supply of LPG cylinders. The facts of the case were like Indian Oil Corporation, that is IOC, entered into a contract with the Amritsar Gas Service, the distributor, for the supply of liquefied petroleum gas, that is LPG cylinders. These were issues regarding the supply and payment terms between the parties, leading to a dispute. Now, Amritsar Gas Service raised a claim against IOC for failing to supply LPG cylinders as per the contract and not fulfilling its obligations under the agreement. The main issue in this case was whether the IOC, by failing to fulfill its obligations of timely supply under the contract, had breached the agreement with Amritsar Gas Service and whether it was liable for damages. The Supreme Court decision in this case was it was in favor of IOC. The court held that distributor, that is Amritsar Gas Service, was not entitled to claim damages or penalties because there was no breach of the contract by IOC. The court emphasized that terms of the contract and the stipulations for delivery had been duly followed by IOC, and any delay or non-performance by IOC was not intentional or resulting in a breach that would warrant compensation. The principle this case highlighted like importance of contract terms and the obligations of each party under a supply agreement. It reinforced the idea that unless a breach is evident, parties can't claim compensation or penalties without clear proof of non performance of contractual duties. So you have to show clear cut violation of terms and conditions of the contract. And unless that breach is evident, the parties can't claim compensation. Significance of the case is that you need to understand in context of understanding the obligations of supply contract, basically particularly in the oil and gas industries. It clarifies that a party can't claim compensation without substantiating the existence of a breach in the contract terms, and underlines the importance of fulfilling contractual agreements in a timely manner. Case law 5, that is MC Mehta वर्सेस यूनियन ऑफ इंडिया 1987 का केस है, या ये 1987 सुप्रीम कोर्ट 1086 ओलियम गैस लीक केस भी इसको हम कहते हैं. बेंच जो थी चीफ जस्टिस PN भगवती की, जस्टिस RS पाठक जी की और जस्टिस GL ओझा जी की थी. और सुप्रीम कोर्ट ने इस इन्वायरमेंटल लॉ केस में एम्फेसाइज किया, क्या एम्फेसाइज किया, दैट इन इंटरप्रेटिंग स्टैट्यूटरी प्रोविजंस लाइक इन्वायरमेंट प्रोटेक्शन एक्ट in a way that aligns with earlier decision, especially when statute is ambiguous in its application. The court utilized precedents in environmental law cases to support a broader interpretation of environmental statutes, ensuring consistency in the law's application. Background of the case, that in December 1995, a hazardous oleum gas was leaked from one of the units of Sri Ram Foods and Fertilizers Industries, a subsidiary of Delhi Cloth Mills Limited in Delhi. Now, this happened soon after the Bhopal gas tragedy, that is in 1984. Once again, it heightening the public concern that the gas leak resulted in the death of an advocate, caused illness among several people. Now, public interest litigator MC Mehta filed a writ petition under Article 32 of Indian Constitution seeking the closure and relocation of the plant due to its hazardous nature and the threat it posed to life and health. Legal issues were like whether hazardous industries should be allowed to operate in densely populated areas, number 1. Number 2, what standard of liability applies to enterprises engaged in hazardous or inherently dangerous activities, whether the principle of strict liability, number 3, or a more stringent form applies in such cases. The judgment, Supreme Court delivered a landmark ruling introducing the absolute liability principle. The court held that an enterprise engaged in hazardous or inherently dangerous activity owes an absolute and non-delegable duty to ensure no harm results to anyone. If harm occurs, the enterprise is absolutely liable regardless of negligence or fault. यानी गलती हो या ना हो, अगर हार्म हो रहा है, इंजरी हो गई है, तो जो भी कंपनी है, जो भी ऑर्गेनाइजेशन है, वो एब्सोल्युटली लाइबल है. नो एक्सेप्शंस लाइक रेलेंस जो वर्सेस फ्लेचर का जो केस था, जिसके अंदर डॉक्टर स्ट्रिक्ट लाइबिलिटीज़ थी, जिसके अंदर कुछ एक्सेप्शंस थी. Absolute liability has no exception. Even if it is an act of God or third party fault, it does not exempt the enterprise. The compensation, like enterprise must compensate all those affected adequately and safely. The court emphasized the need for a new jurisprudence in India that suits its socio-economic conditions. Now, constitutional provisions like the judgment reinforce the importance of Article 21, that is right to life, and the state's duty to protect the environment. Significance, it established absolute liability as an Indian environment law's backbone. It strengthened the public safety norms for hazardous industries. Number 3, it paved the way for future environmental jurisprudence, including the polluter pays and precautionary principles. Case law 6. यूनियन ऑफ इंडिया वर्सेस दिनेश इंजीनियरिंग कॉरपोरेशन 2001 का केस है, सुप्रीम कोर्ट केसेस में रिपोर्ट हुआ, बेंच जस्टिस आर सी लोहाटी जी का एंड जस्टिस बी एन अग्रवाल जी का। द केस कंसर्न्ड कॉन्ट्रैक्ट लॉ and emphasize the need for courts to interpret ambiguous contract clauses by referring to earlier judgments. This decision upheld the importance of doctrine of stare decisis, ensuring that courts remain consistent in interpreting statutory and contractual language. Background of the case was like Dinesh Engineering Corporation was awarded a government contract for the supply of railway components. A dispute arose regarding performance and payments, leading to arbitration as per the contract terms. The arbitrator passed an award in favor of Dinesh Engineering Corporation, granting compensation. The Union of India challenged this arbitration award under Section 30 of Arbitration Act 1940, arguing that the arbitrator had committed legal errors and the award was liable to be set aside. The key legal issues were whether the arbitrator exceeded jurisdiction or committed errors of law. Number 1. Whether the award could be set aside under Section 30 of the Arbitration Act 1940. Judgment. The Supreme Court upheld the arbitration award and dismissed the appeal by Union of India. The court emphasized that an arbitrator is the final judge of the facts and law unless the award is patently illegal or beyond jurisdiction. Courts should not interfere with arbitral award merely because they would have interpreted the contract differently. There was no error apparent on the face of the award, nor any misconduct justify its annulment under Section 30. So, significance of the case is that it reaffirmed the limited judicial interference in arbitral award, highlighted the principle of finality in arbitration, increasing faith in alternative dispute resolution mechanism. It clarified the errors of interpretation by an arbitrator do not automatically render the arbitral award invalid. So, case law 7 state of UP versus सिंघारा सिंह 1964 का केस है। बेंच जस्टिस के सुब्बाराव जी का, जस्टिस JC शाह जी का, जस्टिस N राजा गोपाला अयंगर जी का। Key principle in this case that the Supreme Court interpreted a statutory provision in a way that followed the principles established in earlier cases, stressing the fact that past decision should be crucial to determining the legislative intent. Significance. The case underlined how judicial precedents must guide interpretations when there is lack of clarity in statutory provisions. Background of the case was that this case dealt with the interpretation of Section 164 of the CRPC 1898. Now it is retained in similar form in CRPC 1973, which deals with recording of confessions and statements by a magistrate. Singhara Singh was accused of murder. During investigation, a confession was allegedly recorded by a police officer purporting to act under Section 164 CRPC. This confession was used as key evidence in trial proceedings. Legal issues were: number 1, whether a confession recorded by someone other than a magistrate under Section 164 CRPC is admissible. Can compliance with procedural safeguards, number 2, invalidate a confession? Judgment. The Supreme Court ruled in favor of Singhara Singh, holding that only a magistrate is authorized to record a confession under Section 164. Number 2, a confession recorded by a police officer, even it follows some procedure, is not admissible in court. Number 3, procedural safeguards under Section 164 are mandatory to ensure that voluntariness and authenticity of confession. Any deviation from these procedures renders the confession inadmissible as evidence. Significance of the case is that it reinforced the sanctity of the procedural safeguards in criminal justice. Number 2, it emphasized the inadmissibility of confession not recorded according to law. This case is landmark authority on the interpretation of Section 164 CRPC and protection of accused under coercion. Conclusion. Now these cases which we have discussed, like 7 cases, they emphasize that precedents play a pivotal role in interpreting statutory and constitutional provisions, particularly in face of ambiguity. The court often rely on past decisions to ensure consistent and predictable legal आउटकम्स, ये बड़ी इंपॉर्टेंट बात है। कोर्ट्स ऑफन रिलाई ऑन पास्ट डिसीजंस टू इंश्योर कंसिस्टेंट एंड प्रिडिक्टेबल लीगल आउटकम्स, राइट। तो आशा करते हैं आपको हमारे लेक्चर पसंद आ रहे होंगे। आप हमें एक्स पर, इंस्टा पर और फेसबुक पर डॉक्टर अनुपम आचार्य के नाम से फॉलो कर सकते हैं। आप हमारे फेसबुक पेज डॉक्टर अनुपम आचार्य नंबर 1 मोटिवेटर एंड ऑथर को भी फॉलो कर सकते हैं। यदि आपको वीडियो पसंद आए तो इसको लाइक करिए, शेयर करिए और नोटिफिकेशन बेल को दबाना ना भूलें। चैनल को सब्सक्राइब करने के लिए आपका बहुत बहुत धन्यवाद। थैंक यू दोस्तों।